Yes. So classic situation which this arises is in Chapter 7. So let's say, for argument's sake, you file a Chapter 7 bankruptcy case and you have a car loan. Well, a car loan is a special kind of a debt called a secured debt. A secured debt is a debt that's secured by a tangible asset. If you don't make the payments, the creditor can retrieve the asset. So if you don't make the payments on the car loan, creditor is going to repossess and turn around and sell it, and you'll be on the hook for the post-resale liability. That's outside of bankruptcy. Inside of bankruptcy, you have three options with a purchase. Option number one, you can simply surrender the car as part of the bankruptcy. When you surrender the car as part of the bankruptcy, it converts that debt from a secured debt to an unsecured debt. That means there's no collateral that can be repossessed if you default. And then that debt's just discharged in the bankruptcy. So this makes a lot of sense if, for example, you're way, way underwater on the car. You've got a car that might blue book at $10,000. You still owe $20,000. The payments are too high. You're having a dickens of a time. You figure just let it go. So that's option number one. You can surrender. Option number two is only in Chapter 7. This is an unusual option, and you'll see why as I describe it. You can redeem the car. Now, what's going on with redemption? With redemption, you're just going to pay it one big payment, and then the car is yours, end of discussion. Well, if you're in a Chapter 7, you probably don't have the kind of money necessary just to pay off a car loan in one fell swoop. So why would somebody even want to do this? Where's the benefit? I mean, you're just paying it off? Well, here's the benefit. When you redeem, you get to redeem at fair market value rather than at the current balance of the loan. So if you have a scenario such as I described a couple minutes ago, where you have a car that's worth $10,000 and you still owe $20,000, you can take that $20,000 debt, jam it down to $10,000, pay it off, and now you've just eliminated $10,000 worth of debt on the car. The catch, though, is you can't do it in a series of payments. It has to be one big payment, and that's why it's very rare. Unless you have a family member or friend who's going to chip in, you're probably not going to be able to redeem. But if you can, there's the benefit. The third option is what was the topic that you asked me to discuss, and that is reaffirmation. So the third option is you can keep the vehicle, continue to make regular payments, but you typically have to satisfy three requirements. Number one, you must be current and remain current on the payments. Number two, you must be current and remain current on the insurance. And number three, if the creditor insists on it, the bankruptcy code does permit the creditor to insist that you reaffirm the debt. What does that mean? It helps to know what happened when you went and bought the car. When you bought that car, you reached into your pocket and realized you didn't have enough money to pay cash. So what did you do? You took out a loan. When you took out that loan, two things happened. Now, they happen simultaneously, so you might not think of them as two separate events. But for our purposes right now, it's handy to bifurcate them into two separate events. Number one, the creditor got a security interest in the car. What does that mean? It means if you don't make the payments, the creditor can retrieve the car. What have I just described there? If you think about it, I've just described a claim the creditor has against the car. Now, the car is a thing, and in law, we refer to a claim against a thing as an in rem claim. And the reason for that is the Latin word for thing in the appropriate objective case is rem. The second thing that happened is you as a human being became personally liable on the debt. What does that mean? Well, it means if you don't make the payments and the creditor takes the car back and turns around and sells it for less than you owe, it gets to come after you to collect the post-resale deficiency. So that's a claim against you as a person. So it's referred to as an in personam claim. The big picture goal in bankruptcy is to address in personam claims. And in Chapter 7, it's just to erase them. In rem claims you generally can't just erase. but in personam claims, you can. So if you did that Chapter 7 bankruptcy case and you took no further action, you got your discharge, and subsequently you became unable to make the payments, and the creditor repossessed the car and sold it for less than you owe, you'd owe precisely zero, because there's no in personam liability anymore since that was discharged in the bankruptcy. Well, creditors don't like that. So they paid a lot of money to a bunch of questionable people in Washington, D.C., and they got the law changed so that now what the law says is, if the creditor wants to, it can insist that you resurrect that in personam liability against you. That process is called reaffirmation. So mechanically what happens is we file the petition, the creditor gets notice, sees that you have this car loan and sends me a reaffirmation agreement. If you're comfortable with its terms, you sign it. I send it back to the creditor. The creditor's representative signs it, files it with the court, and then the judge will set it for a hearing. In theory, if you refuse to sign the reaffirmation agreement, the creditor can repossess even if you're current on the payments. Although the automatic stay is still in place, the creditor would have to have the stay lifted. If you refuse to attend the hearing, the creditor can repossess the car even if you're current on the payments because you didn't comply with this requirement in the bankruptcy code. But suppose you go to that hearing, and this is an unusual hearing in the sense that the judge is on your team wanting to make sure you're not being railroaded into something you can't handle. The judge is going to ask you just a couple of questions, one of which, and the wording varies from judge to judge, do you have enough income after covering your other living expenses to make the payments on this debt if I approve this reaffirmation agreement? Now, you absolutely cannot lie. But if you can say something to the effect that, Your Honor, I'm having a Dickens of the time, I'm not sure I can, well, then the judge will disapprove the reaffirmation agreement. As long as you remain current on the payments at that point, the creditor cannot possess the car because it's not your fault. It's the judge's fault. Now, a lot of judges in the Central District are loath to approve reaffirmation agreements because they want people emerging from bankruptcy with as little in personam liability as is possible. Sometimes a debt has an in personam component to it, and it's not dischargeable anyway. Typical example, a student loan. But if you can get rid of in personam debt, well, judges tend to prefer that, so they don't really like to approve a reaffirmation agreement unless there's a real improvement in the terms. Say the creditor has lowered the balance, has lowered the interest rate, something like that. In California, where I practice, the legislature enacted and the governor signed into law a statute the beginning of this year, this is 2023, changing the law in the sense that the creditor cannot repossess as long as you are current on the payments, regardless of any reaffirmation. There is some tension here because that's a state law and bankruptcy is federal law, and because of the doctrine of federal preemption that's found in Article 6 of the U.S. Constitution, the federal law always wins. Thus far, nobody has challenged the constitutionality of that particular law. But generally speaking, if you can avoid it, it's a good idea to avoid reaffirming a debt. Now, sometimes a creditor will try and toss in a sweetener. Well, if you reaffirm the debt, we will report your on-time payments to the credit reporting bureaus, thus accelerating your improvement on your credit. Well, depending on how much that in personam debt is, that might be an expensive proposition. So my own situation or my own feeling on this is it's best not to reaffirm if you can avoid it. But if you really want to, well, then you're going to have to get the judge's permission. I do not sign reaffirmation agreements because I don't think it's in the best interest of my clients. Because if I sign it, then the judge will just rubber stamp it, end of discussion. There's nothing more to do. But that's something that I have to discuss with each client who's in that situation. And there isn't necessarily a one-size-fits-all in that context. The other thing you asked about was lease assumption. Now that's different, even though on a superficial level it seems to be the same topic. And this frequently comes up in the context of a car. But of course, this can also come up if it's a lease on your home. You can have a lease assumption. Oh, by the way, let me add one thing to the reaffirmation, and that is you only have to, a creditor can only insist that you reaffirm a debt on a piece of personal property. There is no provision in the bankruptcy code that allows a creditor to insist on reaffirmation for a real estate mortgage. So that's something just to keep in your mental back pocket if that comes up. With regard to lease assumption, a lease is different from a purchase because in essence, it's a long-term rental agreement. And at the end of the agreement, you're going to have to surrender whatever that asset is back to the entity that was leasing it to you. So the bankruptcy code has a provision that says that you have to state your intention with a lease, whether you're going to reject the lease or assume the lease. And if you're going to assume the lease, then typically the creditor will send to me as your attorney a lease assumption agreement, which is much simpler than a reaffirmation agreement on a purchase. It simply says from now on, the original terms of the lease will control. It's just as if for that lease purposes, you've never filed a bankruptcy case. There is one creditor, and that's Honda, that insists that you sign a reaffirmation agreement for a lease. Well, legally, I think that's just flat out wrong. But thus far, I haven't had a client who is willing to pay for the litigation to challenge the legitimacy of that position that Honda takes. So as it stands now, they insist on a reaffirmation agreement for a lease. And if you can avoid it, generally, I think that's the best approach here. But again, case by case basis, if you become my client and this comes up, we'll talk about it.